Hi, everybody. Welcome back to Health Law Simplified. Uh, this
Hey.
is this is a special bonus episode. We usually do one a month. Today we're doing our second in less than a week. In our last episode, we unpacked the Clover Health ruling and why it matters for Medicare Advantage organizations and star ratings. And right after we put out our episode, actually, we were still polishing up our episode. CMS put out an HPMS memo responding to the Clover Health ruling and announcing its decision to recalculate quality bonus payments for 2027. So we invited Anna and Melissa, our guests from the last episode, back into the studio. They very generously agreed to hop on the phone with us, and they are going to help us walk through what CMS did and what it means for MA and Part D plans. So thanks everybody for joining us.
Yeah, and first of all, wow, like never a dull moment, right? We were just speculating, like, will they recalculate? And then, yeah, I
It
guess
was
so.
shocking.
And the poor actuaries, like right when the actuaries were getting ready to take their couple of weeks off, like they got called back to the bench.
Wow, yeah, I hadn't thought about that. Oh,
Anna,
So
I
what's
know
uh,
you've
interesting
been
is that,
close to the HPMS memo. Would you mind just walking us through what CMS did, how it decided to respond to this ruling?
sure. So as we know, the court ruled that CMS reached beyond the measures the statute authorizes when it built the star ratings for QBP purposes. And so what CMS, the remedy that CMS created then was that we're going to recompute everyone's QBP ratings on the measure set that's anchored to the governing statute that the court ruled out, not the full star ratings program, but actually to the measure set that the court said these are the data sources for which you're authorized to collect data for star ratings. So those were HEDIS, CAPS, and HOS. So two things to hold on to here. So first, CMS did this voluntarily. They're really clear about that in their memo from June 17th, and that they reserve their right to appeal. So we should be looking at this kind of as a remediation, not CMS's settled position on how they're going to treat this moving forward. So in essence, that's what they did. They recalculated every contract star rating based on just including HEDIS, CAPS, and HOS and removing everything else. So that was the plans. Then in the memo, CMS also said, well, this now gives you an opportunity that if your rating changed and it would change your bid, you can resubmit your bid. You had to make a decision about doing that on June 22nd, letting CMS know of your intent, and then bids are due June 29th with actuarial certification due July 1. So plans had 4 days to make this decision. If plans did not choose to resubmit their bid, then their original star rating is going to stand. So what else? What am I missing, Melissa? That was it in a nutshell.
That was a really good synopsis, Anna. I think the one thing that is missing is what it didn't say. You know, we're all about what does the memo say and then what does it not say. One of the things that CMS was really clear was that this was a one-time relief, that this posture was a temporary fix so as to not harm any other plan who might be thinking about filing suit or litigating for the 2026 star ratings. They were really clear this is not a permanent posture or a commentary on whether or not they will appeal, on whether or not the same application of measure removal will be used in a few weeks when CMS releases the 2027 star ratings, and no comment on whether these same measures will be removed from the measurement 26 or the 2028 star ratings. So I think that maybe, like, from a business operator's perspective, I think that might have been the hardest thing for people to really wrap their minds around, was that this was really just a short run fix on how to prevent others from litigating the speed, and it's not an indicator of what comes next. That was a little harder to jump out of the memo for that folks.
another thing I wanted to clarify is that they recalculated the 2026 star ratings, which are used for the 2027 quality bonus payment. So it gets a little, they refer to it in the memo just in terms of the 2027 QBP, but that was based on the 2026 star rating. And they said in the memo that this doesn't necessarily mean anything for future years. Another thing that was interesting to us as lawyers is that they, tying back to the Clover case, there were two arguments in that case. One that had to do with the data sources, and they did recalculate based on that. But the second argument was based on not the data sources, but the issue of notice and comment when measures were implemented. And they did not, that one is kind of, we were calling that more the nuclear argument. CMS did not voluntarily recalculate based on that notice and comment sort of procedural error argument. So it'll be interesting to see, will any plans sue under the ruling based on that argument or not? And you could sort of read the tea leaves and say, CMS potentially thinks it has a stronger case on that argument. I don't know. I don't know. That's speculation.
Well, it could be that they didn't do that because had they done that and applied the logic across the board, there would be no measures to score in order to produce any ratings, right? I suppose plans could go back to the court for relief and say, I pick these measures under that logic, very similar to what Clover did, right? Clover didn't pick every star ratings measure. They only picked certain star rating measures, even though all of them theoretically would have fit under that logic. They only picked a certain set. So to that extent, they're probably still open to some plans going to the well for relief, using that additional logic. It's just they can't use the first set of logic that says you didn't have authority to collect these measures from these data sources. I'm sorry, you didn't have authority to use these other data sources in star ratings. That's a really important distinction. Just authority to collect that data, just not to use it for the data pipes feeding the star ratings program.
Yeah, good point. The other thing that, go ahead, Sandy.
Another interesting choice that CMS made is that it only assigned a recalculated rating if it was higher under the recalculation than the previously assigned rating. And that is not something that a plan is going to get if it decides to go to court. If a plan goes to court with its, hand-picked ratings that it would like to challenge, and a different judge in a different venue opts to order CMS to do a full recalculation, there's always the chance that the plan is not going to end up better off. So I think CMS is hoping that decision will stem the tide of litigation that I still think is out there. I don't, this certainly doesn't resolve all of the potential legal claims, but there was that show of discretion.
Yeah, and Sandy, the timing is really interesting because I look at my calendar. It's June 24th right now. We're literally within weeks of the next round of star ratings being released to plans. We've never been a litigious industry back and forth between generally the payer community and CMS until this star ratings era. Plans are already lining up and beginning to think about how might I respond to whatever comes out in a few weeks with a lawsuit versus improving quality and doing the things that would have been done 5 or 6 years ago. I do think that there's a lot that we need to be watching in the next few weeks. As I understand it, Sandy and Elizabeth, you guys have to confirm that from your legal perspective. CMS only has till the end of July to file their appeal. So by the end of July, we're going to know, is CMS going to battle this? Will CMS have gone to Congress? Will we see some proposed rulemaking flow out with speed or not? Think about this. It's only been a month since we had this ruling issued, and we've already been through like 8 seismic issues. the next month I feel like it will be
Mhm.
similarly full of that kind of news while we prepare for the fall.
I'd be shocked if they didn't appeal because of especially because of the nuclear sort of second part of the court's holding with respect to the procedural deficiencies, but we'll see.
Yeah.
I would agree. And to go back to your point, Sandy, around the hold harmless, when you think about how many plans went up, many, many more plans would have gone down than would have gone up. So about almost 200 plans, it's estimated, would have had a decrease in their star rating if this was calculated this way. This should give everybody pause, right? You should know who you are if you're a health plan. Would this have made your rating go down? Because if eventually we end up with that posture, that's something to be very concerned about for your star ratings program. Only about 10% of plans went up and had an opportunity to refile their bid. And by
Can
plans,
you
I really mean contracts. So, and then the majority stayed about the same, or would stay about the same.
can you tell us more about that, about the impact and how it shook out? So the plans that have the opportunity to resubmit bids are plans that were at 3.5 and got bumped up to 4 because of this recalculation. Can you, you guys are closer than we are, to sort of the impact and how it shook out?
So if it would have changed your um, your QBP, if it would have changed your posture, in other words, your rebate percentage or your QBP amount, and that could also be plans that went from 3 to 3.5, right? There's a change that happens there. There's a rebate percentage change that takes place there. From 3.5 to 4, there's also a change. 4 to 4.5, there's a change.
Okay.
4.5 to 5, there is no change. So that's interesting. The benefit from 4.5 to 5 is not really a QBP and rebate percentage situation. It's about year-round open enrollment for your plan, that you're able to receive members year-round. So that's an interesting point, right? That there were many different types of plans that would have been affected.
So that's very helpful. And so looking forward, if this change is implemented for next year, were you saying that more plans would be downgraded vis-a-vis the old methodology than upgraded?
If performance remained the same as what we saw for
Okay.
2026 star rating, if we wouldn't see improvement, right? If we saw kind of similar performance or steady performance in those measures, then yes, we would expect to see many contracts under that logic of only using HEDIS caps and HOS, eliminating all of Part D measures. We would see many, many more contracts star rating go down than we would go up.
Wow. Okay. That's interesting.
Okay, can I drop some good spicy other things to think about here too?
Please.
Let's not forget,
Please
because
do.
as you guys described that, as we described that, Anna, it's also important to remember, nobody in the Part D space is just going to roll over and be happy.
Right. Sure, no problem.
Disappeared. I mean, you've got PQA who spent 20 years anchoring to procedures and processes to measure quality in Part D. You have CMS and HHS that have long since supported having metrics of quality evaluation in Part D. If you think about pharma and the PBMs, there's been it's almost difficult to quantify the time, the labor, and the dollars spent towards Part D and Part D quality. So I do think that there's like this funny little misnomer. Everybody's like, well, what if they just evaporate? I mean, Medicare Advantage and star ratings has always been a political game as much as a quality game. We know, just as folks are thinking about what would happen if these measures disappeared, we do have to remember, what if they don't? And what do we do in the meantime while this is a tempting idea of thinking they might disappear? What if they stay? And also, again, back into sort of spicy things to be thinking about, don't forget that a couple of days before or after, I can't recall off the top of my head, before this HPMS memo came out, CMS issued an RFI around 2028 PBM reform. So we're already in this weird environment where the November elections are coming up. Nobody expects the current administration to keep its trifecta whole. So I do think we need to sort of think really thoughtfully about what we're doing here with a more sophisticated, savvy game of chess in front of us, rather than sort of a HPMS memo says X, we're going to play checkers and put our bets here and flip red or black on the roulette table, because this is feeling both like a congressional thing, a court thing, a political thing, and it's not feeling as simple as might they stay or might they go. To me. I don't know about you guys.
That's a good insight.
Absolutely. I think, this administration has shown us that they want to make big changes in risk adjustment, in star ratings, and, this lawsuit may be an opportunity for CMS to double down on reshaping the program. We're used to agencies that want to maintain the status quo, but that's not necessarily the case here.
That's right. And so again, like when we think about how far ahead should we be thinking, we really have to get ourselves through the end of July. We have to see, does CMS file the appeal and try to keep stars and quality bonus payments as they are? Or, there's nobody that would dispute this administration didn't like QBPs. MedPAC has been after stars and QBP for a decade. Paragon's been after QBP and stars. Might this administration choose not to appeal because failing to appeal would give them a speedy necessity before November to reimagine something while they still have political control, which they might not be able to do post-November in the next 2 years. So I think there's just a lot to be thinking about here, underneath, above, and around this HPMS memo, in my opinion.
Yeah, absolutely. And I also want to be very clear, this HPMS memo was limited to 2026 star ratings, 2027 quality bonus payments. I know, all of the plans are thinking forward, but there are still all of the previous year's quality bonus payments and, statute of limitations to go after the government in a breach of contract action is 6 years. So that's, at least 6 years of quality bonus payments that plans will probably want to be looking at to see if there's enough of an impact to justify a suit.
Yeah, I think from what we've been talking with our clients and friends about, I think that's what plans are trying to figure out right now. Budgets are tight. The federal government is a volatile entity to sue against, and filing suit of this nature is expensive. So I think folks are really looking, do I have the legal budget to go backwards and look at all of those open contract years and think about a 6-year backwards looking breach? What would I do if I won? If they win the money, what would they do with the money under the Medicare Advantage regulatory structure? And let me go back. Do I have the money and the political wherewithal to go back and file suit for historical times? I think that's why we've not yet seen this race to the courthouse and the retro view. I think folks look to see if perhaps CMS might come out with a retro fix that felt similar to this modern 2026 fix.
Yeah, we also had to see how CMS was going to recalculate, right? Because if they just flat out recalculated and not changed any of the other rules, then there wouldn't have been enough measures to calculate a rating once Part D was removed. So we had to see what other things did they have to change. So we saw that they had to recalculate the categorical adjustment index. They had to recalculate reward factor thresholds. So it was really interesting to see CMS, how they applied, they just applied star ratings, the logic of the ruling, but then which parts of the methodology they kept intact and which parts of the methodology they had to bend a little bit in order to be able to calculate ratings. And the reason I bring that up is as you are doing your prior year look backs, what plans are going to find is that if they have multiple contracts, for some contracts, they're going to be winners, and for some contracts, they're going to be losers. And for some years, they're going to be winners, and for some years, they're going to be losers. So it's really complex math that has to go into place, and complex rationalization, really, for which way do we move and do we take action and when. So very important things to think about.
Yep. Also from a legal perspective, y'all, it's very interesting. Like Anna said, they basically made up a new rule set to do this whole harmless recalculation, which is fascinating because when they made up this approach and they removed all the Part D measures, that renders, by technical rule in the technical specifications document, that renders every plan with no overall rating. What that should have done is meant that every plan got a 3.5% QBP, because without an overall rating, you couldn't get the 5% QBPs or all of the rebate differentials. You had to set 3.5% at a different rebate number. So I think like, from a legal perspective, I think maybe again, I think folks are trying to catch up on what this bid recalculation or resubmission was all about. And now I think we're going to be watching people settle back and saying, okay, did CMS actually apply this unique made-up algorithm in a way that actually held every plan harmless? Or are there other plans that were not actually held harmless because they should have had no rating and they should have had the 3.5% QBP
That's right.
plans? Like, there's so many funny little permutations here that I think we just all need to like know that we're not like closing the nail in the coffin here. We're just opening the next Pandora's box, it feels like.
Well, and is there a possibility that any other party would have standing to sue and say, CMS, you didn't have the authority to do that?
Oh, I think for sure. I think
you're paying, government money out with no authority.
Right. Like if I think, Elizabeth, about all of the providers that are sitting under percent of premium contracts, risk-bearing contracts, capitated or delegated arrangements, who has standing and for what reason? It's not just the 170 Medicare Advantage contracts. The parties involved include every plan whose top line revenue is attached to this. So I don't know where the legalities flow, but again, we've got a lot of things to continue sorting out here.
I think that hold harmless point that you just made, Melissa, is really, really important, because you may have been held harmless from dropping a star, but you're not held harmless from the rest of your competitors in the space now, artificially gaining a rating. And when I say artificially, I mean some of these things that Melissa just so elegantly described, right? Some of these methodology changes that had to be applied that are not codified anywhere or not outlined anywhere. And now there are certain plans that are going to be at a disadvantage because their competitors in the market have now received a boost that they didn't have the opportunity to get. And more importantly, we're watching now to see if the national bid amount goes up, right? Because of all of these rebidding that we see, and that could put other plans at a disadvantage. So very interesting development.
Very interesting.
Because they weren't affected by the star rating change doesn't mean that they're not affected by what happened.
It's also reminding me of a previous example. I think it was when the star ratings methodology, there was some example where the Congressional Budget Office, I think I'm remembering this right, sort of slapped CMS on the wrist and said that a demonstration they had done exceeded their statutory authority. So anyway, I'm not remembering the details of that example. It's been a number of years, but there's also
demonstration after the redesign.
No, it was back earlier than that. I think it's when the star ratings methodology first went into effect. It's been a while, but Congress was not happy with the way CMS, exercised its authority. So it's just kind of an example of how, a flipped Congress could come back and say, CMS, you can't just do this. You didn't have the authority to do that.
Okay, I keep coming back to the Tukey situation because everybody wants to draw a parallel between this situation and Tukey. When Anna started scrubbing the CFRs on Tukey, we realized that there was a sentence in the circulated rulemaking documents that was not inserted in the online CFR. We keep wondering if maybe the reverse might have happened here. I mean, the ACA, STARS and TVP went through the entirety of the ACA negotiations.
Mm-hmm.
None of this was a secret. The demonstration wasn't a secret. I keep wondering if maybe somewhere, somehow in the annals of old, dated boxes of paperwork, maybe there actually was the authority and to do all of this, and maybe it's going to show up. Maybe somebody's going to go digging through the archives and find that all of this was actually agreed upon between Congress and CMS, HHS, and even payers, since the ACA didn't come out without, everyone at the table. And maybe we'll be surprised and we'll get some documentation and some evidence that.
Is that somebody, Anna? Is Anna going to find it for us?
Are you going digging in the boxes, Anna, in Washington?
Don't blame me. I don't want to get kicked out of all the rooms, right? So Elizabeth, I did find, I was just like quick typing. It was a government accountability office that said CMS didn't have the authority to do the demonstration project. Remember, the ACA said you can pay extra bonus for 4, 4.5, and 5, and CMS had extended that as a demonstration to 3 and 3.5 star plans at the time, like in that 2012 to 2014.
Yes, that's what I was reading. Thank you so much.
Thinking about, yeah.
I didn't dream it, but I was off by a little bit.
That's what you're thinking about.
Yeah. That was.
Well, thank you so much for coming back on such short notice. I'm anticipating we might end up doing a part 3 and part 4 if there are big developments. If Congress actually gets involved, I think that'll be worth a discussion. If a national files a lawsuit, I'm sure we'll be back here. I do think you all shared some really excellent takeaways and recommendations for the industry, and I think all of those still stand. There's still a lot of work to do, internal modeling, reassessing assumptions, and then also big picture strategic thinking about quality and revenue. So, anyone who hasn't listened to that original episode, go back. It's a don't miss, and keep following Anna and Melissa if you haven't yet, because they're sharing a lot of insights on this and all things MA.
Thanks so much.
Awesome. Thanks, friends.
Melissa and Anna, thanks for joining us.